But the contract of marriage gives no power to anyone over the person or the property beyond what the law defines. That is, under Hindu law, even also similar status is available to a woman. So here, in the marriage, that is like a contract. Though this recitation was made from Holy Quran at the time of marriage, but still it is not a sacrament. So it is a civil contract. So here once we treat marriage as a civil contract, so there must be first the parties must be competent to enter into contract of marriage. Second, there must be offer from one side and the acceptance from the other side. Then there should be a provision for dissolution of marriage, either by will of the parties or by operation of law. So after entering marriage, the parties, they are entitled to certain rights, and also they can enforce those rights by filing suit. So whether marriage is a civil contract or not, it has been settled in the case that is Abdul Qadir versus Salima. Justice Mohammed observed that marriage among Mohammedans is not a sacrament but purely a civil contract, although it is solemnized generally with the recitation of certain verses from the Quran. Though marriage is solemnized by recitation of certain verses of Quran, but this marriage is a civil contract. So that is, if you know what is marriage, that the purpose of marriage, that is, object of marriage is like this. What is this? That is for sexual pleasure. Second, to legalize the relationship between the man and the woman, and that is ordering of domestic life, the increase of the family, the discipline of the same in the care and responsibility of wife and children, and the upbringing of the virtuous children. So an object of marriage is regarded, that is, first, this after marriage, there is restraint of sexual passion. The parties cannot live sexual relationship outside other than the husband or the wife. Second, there will be ordering a domestic life, then the increase of the family, procreation of child, discipline of the same in the care and responsibility of wife and children, the upbringing of the children also. So, what are the essential of a Mohammedan marriage? In the Muslim community, certain social functions and ceremonies is also performed, like Hindu marriages. At the time of such functions are not legally necessary. It is not legally necessary. But in Hindu marriage, how marriage is to be performed? That marriage is to be performed, solemnized, according to the custom or the rights of either of the parties. So, for the validity of a marriage, there should be first, this party must be competent. Who is a competent party? So, marriage, dower, divorce. For that, this Indian Majority Act is not applicable. But in case of Hindu marriage, you know that the bride must have completed 18 years of age and the bridegroom must have completed 21 years of age. But here, in Mohammedan law, the parties are competent to marriage once the party has attained the age of puberty. Age of puberty. Age of puberty means to procure a child, to bear a child. Usually the age of puberty is accepted as 15 years. So even a minor can marry by the guardianship as per the under the authority of his guardianship. A guardian can act in the marriage and marriage can be performed. So here, first the parties must be competent to marry, and it must be followed that should be an offer or proposal made by on behalf of one of the parties. This is not necessarily only the husband will also give the offer, but on behalf of the parties to the marriage and accepted by proposal either by the other party, either by himself, even by his agent or through his wakil also. So here, but that must be the acceptance must be to the hearing of two male witnesses, or one male witness and two female witnesses, who must be sane and adult Mohammedans. This only witnesses must be Mohammedan, sane. So first thing, the parties must not be insane also. The parties must not be insane. Then they must have attended the age of puberty, and proposal will be in the marriage. There should be a proposal made by or on behalf of one of the parties. Made by or on behalf means either party himself has give a proposal for marriage, or any other person through his guardian. A guardian can also, who are the guardian who can act? A guardian in the marriage, the list is there. Father, mother, grandfather, brother, they can act. Any of them can act as a guardian in the marriage. So here proposal either may be made by the party or on their behalf, through his guardian or in wakil or his agent. That proposal must come and the other party must accept. By or on behalf of the other party will accept that proposal. Then to the hearing of two male Mohammedan witnesses who are same, or one Mohammedan male witness and two female witnesses. If any of these requirements is not complied, is not fulfilled, the marriage becomes either void or irregular. So you should know, first, marriage is a civil contract according to the Mohammedan law. The purpose of marriage is to legalize the sexual relationship between two persons of opposite sex, and that is to create a family, to lead a domestic life, that is to cure children, to bring the children, and to discipline of the same. They must be disciplined, and also they must regularize their sexual relationship. These are the object. For essential of marriage, that the Muslim, that is, parties must be Muslim. First, what parties must be Muslim. Even a Shia Muslim, a Sunni Muhammadan can marry a Shia woman. But the other requirements will also are required. First, the parties must be competent. Who is a competent party? The Muslim, the parties are Muslim by religion, or then they must have attended the age of puberty. What is the puberty? Puberty is accepted as 15 years. That is, puberty means able to procure child. To procure child, that is puberty. But the marriage must be solemnized by giving a certain recitals from the holy version of Quran recited at the time of marriage. But it is not legally necessary. But there must be a proposal from either party, either by himself or on behalf of that party. That must be accepted by the other party or on behalf of that other party. And in one session, in the same session, this proposal and acceptance must be made. Not indifferent. Today proposal is given. After 2 days, this proposal is accepted. No. So in the same session, there will be same meeting. In the same meeting, the proposal is to be accepted. And there must be two male witnesses. That acceptance must be within the hearing of two male witnesses or one male witness and two female witnesses. So this requirement is not fulfilled, then the marriage is not valid. Marriage, like any other contract, that is constituted by jab o kabul, that is by declaration of an acceptance, Kabul. The other party will declare the acceptance by Kabul. One party of the marriage must make an offer, that is ijab. Offer is called ijab. One party will give an offer, that is ijab, and to the other party, and the other party will Kabul it. The marriage becomes complete only when the other party accepted that offer. That is what is Kabul. The word conveying proposal and acceptance must be uttered each other's presence. The offer acceptance must be uttered in presence of each other or in the presence of the agents, that is wakil. In the case, are uttered in each other's presence. If the parties should hear the word, the transaction of proposal and acceptance must be completed at one meeting. This transaction of proposal and acceptance, that is ijab and Kabul, must be completed in one meeting. There must be reciprocity behavior between offer and acceptance, and that must not be conditional offer, conditional acceptance. A offer to marry B on 1,000 dower, but B accept the proposal subject to dower of his should be paid to his or dower. There is no reciprocity between offer. There must be free consent between offer and acceptance. So under Sunni law, the proposal and acceptance must be made in presence of two male or one male and two female witnesses who are same, adult and Muslims. Absent witness does not render marriage void but voidable. If witnesses are not taken in the marriage, then that marriage is not void but is a voidable marriage, that is fasid marriage. Under Shia law, witnesses are not necessary at the time of marriage. So while answering a question, you should, if you are aware there is any difference between Shia and Sunni law, that must be mentioned in your answer paper. So under the Shia law, no necessity of witness are not necessary under the Shia law. The parties contracting marriage must be acting under their free will and consent. Again, the parties, when they enter a marriage, they must act under free will and consent. The consent should be without fear or under influence of fraud. The consent must be without fear and influence of fraud. In the case of a boy or a girl who has not attained the age of puberty, the marriage is not valid unless the legal guardian consented to it. If who has not attained puberty age, then guardian by this minor, the consent may be the consent must be by the legal guardian. So what is then capacity for marriage? The party to a marriage must have the capacity to enter into a contract. In other words, they must be competent to marry. That is, the parties must be able to understand the nature of their acts. Parties must be able to understand the nature of the act. Every Mohammedan of sound mind who has attained the age of puberty may enter a contract of marriage. Then who can marry? What is the age? Age of marriage is attained of puberty. That is 15 years, it has been accepted. Every Mohammedan of who is not insane, that is, who is able to understand the consequence of marriage, he can enter a contract of marriage. Lunatic and minors. When lunatic can marry, yes, but lunatic and minor who have not attained the puberty may be validly contracted the marriage by their respective guardians. Even a lunatic can marry through a guardian. So, a marriage of a Mohammedan who is of sound mind and has attained puberty is void if it is brought about without his consent. Even if a marriage is made by a Mohammedan who has attained puberty with a sound mind but he has no valid consent, there is fraud or there is what is consent passed, parties must have given free consent. If consent is not there, then the marriage is not valid. In Muslim law, age of majority is understood with reference to attaining the age of puberty. Under the Muslim personal law, what is that? So far as marriage, dower and divorce are concerned, this Indian Majority Act, that is this 1875, is not applicable to a Muslim. So this is that is, who was now a girl under 17 years was given in marriage by her grandfather without her consent. In this case, Ghulam Bibi versus Muhammad Safi. So in this case, the girl left the husband home and came to her grandfather's home. Husband wanted to restore casual life. When the girl said he was never married to the petitioner, the court held that the marriage has not taken place because consent of the girl was not there. Though there was no marriage because the girl had not consented. If this is there, so a man who was a Muslim man or woman who has attained the age of puberty can marry. That, but if he is less than 15 years old or not attended the age of puberty, or an insane person, insane man, insane woman can marry to their guardian. So then who can act as a guardian? The right to contract to give a minor in that is married belongs that is successively to the following persons. First is the father. The father is not there, then paternal grandfather, how high soever, even paternal great grandfather. Then no father, no paternal grandfather, then brother and other male relation on the father side in the order of inheritance enumerated in the table of residuaries. Thereafter the mother, the maternal uncle and aunt are other maternal relations without the prohibited decree and the state. So under this here law, only the father and the paternal grandfather however are recognized as guardian. But under Sunni law, not only father, grandfather, great grandfather, but also in their absence, the brother and other male relatives, male relation from the father side, or in their absence, the mother, then maternal uncle, aunt, they can act as a guardian for the marriage. In certain circumstances, a minor contracted in marriage by the guardian for marriage has the right to repudiate the marriage. This is called option of puberty. What is option of puberty? Once a marriage has been performed through guardian of a minor, then after attaining puberty, that is 15 years and below, before 18 years, then the minor bride may repudiate the marriage. In certain circumstances, minor contract, both the bride or the bridegroom can cancel the marriage, repudiate the marriage, that is in certain circumstances. A minor contracted in marriage by the guardian has the right to repudiate or ratify the marriage on attaining the age of puberty. On attaining the puberty, this minor Muslim may either accept the marriage or repudiate the marriage. The right of minor is known, this right of the minor to repudiate the marriage on attaining the age of puberty, in case there is a marriage by guardian. So this is called right of puberty. In other words, it is called Khair-ul-Bulugh, that is option of puberty. Then the legal disability means the existence of certain circumstances under which a marriage is not permitted. Second, there must not be legal disability for marriage. What are those legal disability? The following are the legal disability. These are prohibitions have been classified for the purpose of marriage. What are those? Absolute incapacity, relative incapacity, prohibitory incapacity, directory incapacity. These are the following legal disability. What are those disability? First is absolute incapacity. That is absolute incapacity means this affinity, hostage, consanguinity. These are absolute incapacity. In such case, suppose they are related, brother, sister, they cannot marry. That is absolute incapacity, that is by consanguinity. Who is a consanguinity? The list has been mentioned. Affinity and hostage. So this is called absolute this is disability. That is consanguinity means what is this absolute disability? This is this is that is consanguinity. What is consanguinity? Consanguinity means that is a Muslim cannot marry his mother or grandmother, however, that is consanguinity. His daughter or granddaughter, how low soever, his sister, whether full, consanguine or uterine. Full means where mother and father is common. That is, full sister is father and mother is common. Consanguinity, where mother are different but father is common. That is also consanguinity. Uterine, where mother is common but father are different. His niece or grandniece, this is also consanguinity. It is otherwise known as quarabus. His aunt, father, sister, mother, sister, or great aunt, however, whether maternal or paternal. That is consanguinity. This is absolute incapacity. That is, A is consanguinity. Consanguinity is called absolute incapacity. Then affinity. Affinity is also, that is, relative incapacity. What is affinity? A man is prohibited from marrying his wife's mother. His wife's mother cannot marry. Grandmother, however, his wife's daughter, granddaughter, how low soever, wife or his father or paternal grandfather, however, wife of his son, son's daughter, son, how low soever. A marriage with a woman, prohibited region of affinity is void. Marriage with the wife's daughter or granddaughter is prohibited. Only if the marriage with wife was consummated. If wife marriage has not been consummated, that is void. Fosterage also. When a child under the age of 2 years has been suckled by a woman, after so it is own mother, the woman becomes the foster mother. Foster means what? This palito. That is, what is that? Suppose a child was suckled the breast, the milk of the woman. With there is prohibition for marriage, that is called reject. When a child under the age of 2 years has been suckled by a woman other than its own mother, the woman becomes the foster mother of the child. Then the foster mother of the child, and that mother, son, daughter cannot marry that child. A man may not, for instance, marry his foster mother who has suckled the breast of the mother, suckled the mother, or daughter or his foster sister. There is exception in Muslim law. Under Sunni law, there are few exceptions to the general rule of prohibition on the ground of fosterage. That is, sister's foster mother, foster sister's mother, foster son's sister, foster brother's sister. The Shia jurists place fosterage and consanguinity on the same footing and refuse to recognize the exception primarily by Sunnis, permitted by Sunni law. So this is, so you see, all those things must be remembered. It is like an history, you should remember. Relative incapacity. What is that? Absolute incapacity. Who are absolute incapacity? The incapacity is by consanguinity, that is affinity and fosterage. These types of three relationships are called absolute incapacity. You cannot marry at all. Consanguinity, as I told you, what the consanguine? Mother, grandmother, daughter, as mentioned, full consanguinity, uterine consanguinity. Then second, affinity and fosterage. With this, there is absolute incapacity to marry. Then relative incapacity. There are four types of incapacity: absolute incapacity, relative incapacity, prohibitory incapacity, and directory incapacity. First, the absolute incapacity, consanguinity, affinity, and fosterage. These are the three relations are treated as absolute incapacity. Relative incapacity arises from cases which render the marriage invalid only so long as the cause which create the bar exists. That is relative incapacity. That is the moment it is removed. It is otherwise called facet marriage. Only once, that is total absolute in this incapacity, that those are void marriage. That is batil marriage. So relative incapacity that arises from cases which render the marriage invalid only so long as the cause which create the bar exists. So long the, suppose a Mohammedan marriage, when a Mohammedan male having 4 wives, he marries another woman. So here it is called facet marriage. So once one marriage, that marriage is totally not void, but once this one of the wife, if he, out of that 4 wives, he gives divorce to one, then that marriage becomes void. So here, that is, relative incapacity arises from the cases which render the marriage invalid so long the cause which creates the bar exists. So long the cause which creates the bar for marriage exists, there is no marriage. Once that cause is removed, that cause is ceases, then that marriage becomes valid. The moment it is removed, so long the cause which causes the relative incapacity to marry, that is removed, then the marriage becomes valid. The capacity ends and the marriage becomes valid and binding. For that, unlawful consumption. What is unlawful consumption? A man may not have at the same time 2 wives who are so related to other by consanguinity. Suppose, what is this? A Mohammedan man cannot marry 2 women who are related to other by consanguinity. Suppose 2 sisters. They are related by consanguinity. If one of them is a male, then she cannot marry. So that is consanguinity. So a man may not have at the same time 2 wives who are so related to others by consanguinity, affinity or fraternity. Cannot marry 2 wives. Those 2 wives. Why? If one of the wife is a male, he cannot marry the other wife because of this consanguinity or affinity or fraternity. But in Hindu law, here such a provision, suppose a man can marry 2 sisters. But here, because when the polygamy was there, so here, but it is there, a man may not have at the same time 2 wives who are related to other by consanguinity or by affinity or fraternity. If either of them had been a male, if either of the 2 out of those 2 wives, if one of them was a male, he could not marry the other woman because of this consanguinity, affinity or fraternity. The bar of unlawful conjunction renders the marriage irregular and not void. So when there is a relative incapacity is there, the marriage is not void, but it is facet marriage. A Muslim therefore cannot contract a valid marriage with his wife's sister till his first wife is living or not divorced. Till the first wife is living, or once the first wife is divorced, then the second marriage with the sister is valid. Under Shia law, a Muslim may marry his wife's aunt, but he cannot marry his wife's niece without wife's permission. But Shia law, there is a provision that the Muslim can marry wife's aunt, but not that marry the wife's niece without her permission. Marriage prohibited by reason of unlawful conjunction is void under Shia law. Polygamy is also a relative incapacity. What is that? It is unlawful for the Mohammedan to have more than 4 wives. It is unlawful for a Mohammedan male to marry more than 4 wives. Marriage with a 5th wife is invalid or irregular. If a Mohammedan marriage with a 5th wife, that is irregular, that is facet marriage. A Muslim woman cannot marry more than 1 husband. That is, if she marries a second husband, she is liable for bigamy as per section 494 IPC. So similarly, and such marriages are legitimate. So absence of proper witness, that is also relative incapacity. It is essential among the Sunnis that at least 2 witnesses, same Muslim witness should remain present at the time of acceptance of the offer, that is ijab. So here, and 2 female witnesses must be present, 1 male and 2 female. So, but into a between 20. The witness must be sound mind, adult and Muslim. In Shia law, witness testifying the marriage is not required. Now a question will come, whether a Mohammedan can marry, Mohammedan male can marry, or a female can marry another man, a man or a female outside the religion. A Sunni male can marry a Muslim female or a Kitabiya. What is Kitabiya? Kitab means on books. If any religion is noted down in a book like Christian, Jews, this is called Kitabiya. That woman is called Kitabiya. Only Mohammedan male can marry. But a female, Mohammedan female cannot marry any person other than a Mohammedan male. But so far as a Sunni male can marry a Muslim female or Kitabiya, marrying with a Kitabiya, that is a woman who believes, what is Kitabiya? A woman who believes that his religion is revealed from divine, that is kept in a divine book like Islam. So it is called Kitabiya. The divine dish, that is the religion was revealed, that has been reduced into a book, has been mentioned in a book like Quran. Christianity and Judaism is valid under Sunni law. So a Mohammedan male can marry a female Kitabiya, like that is a Christian woman or a Jew woman. Under Shia law, no Muslim, whether male or female, can marry a non-Muslim in the nikah first. So Shia's law says, no Muslim, whether male or female, can marry any other person who is not a Muslim. However, Shia can contract a mutta marriage with a Kitabiya. Mutta Kitabiya is temporary marriage. So Kitabiya is under Shia law. A Shia Mohammedan can enter a marriage, mutta marriage with a Kitabiya. So now, another incapacity is that woman undergoing iddat. What is iddat? Iddat means after the dissolution of the marriage by divorce or after the death of the husband, the Muslim woman is required to remain in the seclusion, not to keep relations with any other man, so as to confirm whether she is carrying a child of her first husband or not. This is called iddat period. If that Muslim woman was under menstruation, then for a period, or in other cases 3 lunar months. After the death, that is 4 months and 10 days. This is called iddat period. Iddat is described as a period during which a woman is prohibited from marrying again after the dissolution of her first marriage. Iddat period is that period. During that period, a Muslim woman is prohibited to marry another man after dissolution of first marriage. Under the Sunni law, marriage with a woman undergoing iddat is irregular and is void. It is irregular, but under Shia law, it is void. So once the iddat period is over, then the marriage becomes valid. The object of iddat, what is that? To ascertain the pregnancy of the woman, so as to avoid confusion of parenting. The object of iddat is to ascertain the pregnancy of the woman, so as to avoid confusion of parenting. Duration of iddat of widow. If a female woman, a female Mohammedan becomes widow woman, when a person dies leaving a widow, then the iddat period is 4 months and 10 days. You should remember. Second, iddat of pregnant woman. Suppose when the marriage was dissolved by divorce, at that time the woman was carrying a child, then that is still the delivery of that child. If the widow is pregnant and on the death of the first husband, the iddat will not terminate until delivery or miscarriage. Until delivery or miscarriage, the iddat will continue. If delivery or miscarriage comes before 4 months and 10 days, the remaining period will have to be observed. 4 and 10 days. Before, that is, widow means 4 months and 10 days. Iddat of talaq. The period, sometimes you get a question, what is iddat? Iddat is a period during which a Mohammedan woman cannot marry After dissolution of marriage or after she becoming the widow. If a widowhood, then the iddat period is 4 months or 10 days. Suppose when a widow she was pregnant till delivery or miscarriage of the child, if that takes place before 4 months and 10 days, but the remaining period will also continue as iddat period. Iddat of talaq, the period of iddat in case of talaq is 3 courses. If the woman is subject to menstruation, then 3 courses of menstruation. Otherwise, 3 lunar months. If the woman is pregnant, the time for divorce, the iddat will not terminate at delivery. That is pregnant. If the iddat is pregnant, that is the woman is pregnant at the time of divorce, the iddat will terminate on delivery. Iddat when marriage is irregular, the marriage is irregular and parties are separated before actual consumption has taken place, they bound to observe iddat. The marriage is not consummated, iddat has been observed in the case of death but not in the case of divorce. The period of iddat begins from the date of the divorce or death of the husband and not from the date on which woman gets the information. From the date of death. She gets the information after the expiry of the specified term. She need not observe the iddat. When a husband has divorced his wife and has died before completion of iddat, the woman is required to undergo a fresh iddat for 4 months and 10 days from the date of husband's death. So this is iddat. When a husband and wife are alone together, under circumstances which present no legal, moral or physical impediment to maintain intercourse, they are said to be invalid retirement. What is valid retirement and what is invalid? When the husband and wife are alone together under circumstances which present no legal, moral or physical impediment to maintain intercourse, they are said to be invalid retirement. The valid retirement has legal effect as to actual consumption, that is confirmation of marriage, establishment of paternity, observation of iddat. This is iddat period. So now you know this is this iddat period. Then let us now discuss what are the kinds of marriage under Mohammedan. On the basis of the validity of marriage, marriage may be of 3 kinds. Sometimes, most of the time you get a question, what is Muslim marriage? How it is dissolved? Usually such a question is coming because there is no other question. That is a very important topic of the Muslim law. So kinds of Muslim marriage are valid marriage, void marriage, irregular or invalid marriage. In other words, these are called Sahih marriage. That is, Sahih marriage means valid marriage. Sahih marriage, that is valid marriage. Void marriage is called Batil marriage. Irregular or invalid marriage is called Hasid marriage. So what is valid marriage? What are the requirements for a valid marriage? A marriage to be valid must satisfy this at least 5 conditions. For a valid marriage, that must satisfy the following, that is 5 conditions. First, there must be a proposal by one party and accepted by the other. Proposal and acceptance must have been taken place in one meeting. The consent by the parties is free. The parties must have capacity to contract marriage. There should be no impediment to marriage, either whether absolute, relative, or prohibitory restriction. That is restriction like consanguinity, affinity, fosterage. There must not be any impediment to marriage. So first thing, what is for valid marriage? Marriage to be valid must satisfy the following, that is the requirements. First, parties must be, that is must not be incapacity to marry. Second, there must be a proposal by one party and accepted by other party. Proposal and acceptance must be in one sitting. That is, and that Acceptance must be in case of Sunni marriage be made in presence of two male witnesses, Muhammadan sane witnesses, and or one male sane and one male or two female witnesses. The consent of the parties is free. The parties must have capacity to contract, that is, must have attained the age of puberty. There should be no impediment in marriage. Like what are those impediments? That is this absolute impediment. That is relative, like this consanguinity, affinity, frustrated, etc., or other irregularities. Now, under Shia law, but a batil marriage, a marriage contracted by parties suffering from absolute incapacity is void. Absolutely. They are of no legal effect, and issue of once a marriage is void, they are to be treated as illegitimate child. This marriage is violation of absolute incapacity. Under Shia law, if the marriage is performed by violating absolute incapacity, marriage was wife of another person whose marriage is still subsisting, then remarriage with one's one divorced wife, there is a legal bar, unless there is halal. Marriage prohibited by reason of unlawful consumption, marriage with a fifth wife, marriage during pilgrimage, marriage with any non-Muslim, marriage with a woman undergoing iddah. These are batil marriage. That is, but under Sunni law, suppose a Mohammedan male marries a woman while undergoing iddah, that is a fasid marriage. Once the iddah period, that becomes valid. Marriage with a non-Muslim, that is valid. But once the non-Muslim woman accepts the Muslim faith, then the marriage becomes valid under Sunni law. So, irregular and invalid by fasid marriage. What are those fasid marriage? A marriage contracted by parties, that is with relative prohibitory or directory incapacity. Relative prohibitory, that is from relative prohibitory or directive incapacity is invalid. That is marriage contracted without witness. That is a prohibit. That is a fasid marriage. Marriage with fifth wife, marriage with a woman undergoing iddah, that is fasid marriage. Marriage with a that is non-Muslim, marriage which is by the unauthorized person, marriage by an unauthorized person, marriage contracted, unlawful consumption. So according to Shia law, marriage may be either valid or void. Those marriages which are irregular under Sunni law and under Shia law, however, under Shia law, marriage contracted without witness is invalid, it is not void. So what is the consequence of a void marriage? A void marriage means there is no marriage at all. Effect of before it's after consumption. It does not create any right and obligation between parties. Once the marriage is void, thereby no right and obligation is created between the parties. The wife is not entitled for maintenance. One cannot inherit from the property of others if the marriage is void. The offspring of the void marriage are illegitimate. The parties can separate from each other at any time without divorce and may contract another marriage. Consequence of irregular marriage, that is fasid marriage. The consequence of irregular or invalid marriage may be different angles. So that is before consumption and after consumption. So what is irregular marriage, fasid marriage? In such case, what will happen? It has no legal effect. The wife is not entitled to dower. The spouse may separate from each other without divorce. That is in fasid. Neither before consumption. Before consumption, suppose marriage has not been consumed, but there is a fasid marriage. So here in case the wife is not entitled for dower, they can separate without divorce. But once the marriage is consumed, then wife has to observe iddat. Even after this iddat is required to be even divorced. She is entitled to get specified proper dower, whichever is less. She is not entitled to maintenance during iddat. The children of the marriage are legitimate. The main difference is that in case of fasid marriage, the children of the marriage are to be treated as legitimate. But an irregular marriage, though consummated, does not create mutual rights of inheritance. The husband and wife cannot inherit property from each other, but the children can inherit property. Such marriage may be terminated by a single declaration on either side. The wife is bound to observe it or divorce under the iddat of death. The parties must be separated by courts. So consequence of valid marriage, once a valid marriage takes place, that is valid marriage creates certain rights and duties between the wife and the husband. Once there is a valid marriage, the mutual rights and obligations. It legalizes sexual intercourse. Once there is a valid marriage, that legalizes the sexual relationship, and the children born out of it are legitimate. Husband and wife get a right of mutual inheritance. Once valid marriage, husband can inherit the property of the wife, wife can inherit the property of the husband, and prohibited degree of relationship are created. Thereby prohibited degree, so that they cannot marry within such degree. Right of wife and duties of husband. Then what is the right of the wife and what is the duties of it? It's very peculiar in Muhammad law. So here, the wife is entitled to receive maintenance from her husband. Even she is able to maintain her. She is entitled to get maintenance from the husband. She is entitled to dower as a necessary consequence of marriage, even if no stipulation for dower has been made. She has right to live with her husband and to have an apartment for her exclusive use. Separate room must be provided her for you. If her husband more than one wife, if the husband has more than one wife, she is entitled for a separate room. She has a right to visit and be visited by her blood relation. She has a right that she can go to her father's house, blood relation's house, when they can come also too. Right of husband and duties of a wife. This is very peculiar in Muhammadan law. What is that? She is bound to observe strict conjugal fidelity. Must be always, that is, wife is right to observe, bound to observe strict conjugal fidelity. What is fidelity? But with faithfulness. She must not keep any relation with any other person. She is bound to allow her husband conjugal union with her, with due regard to her own health, decency and praise. She is bound to keep sexual relationship with her husband, with due regard to her health, decency and praise. She is bound to obey her legal command. This is not there in any other law. The wife is bound to obey her legal command. She is bound to reside in his house and to observe farda. You see, this Muslim woman after marriage is bound to observe farda, bound to reside in the house of her husband if necessary. She is bound to observe iddat on her husband's death or divorce. This is industrial. This is the marriage, batil marriage, fasid marriage, and valid marriage. So this is, then the second is that mutta marriage. Mutta means enjoyment. Mutta, what means enjoyment? This is mutta marriage is only permitted in Shia law. Under the mutta marriage, the mutta literally means enjoyment. It may be rendered as, that is, marriage for pleasure. When the mutta marriage means it is marriage for pleasure. It is marriage for a fixed period and certain reward paid to the woman for a fixed period and in lieu of reward paid to the woman. It is prevalent in Shia law. It is not recognized in Sunni law. Sometimes you get a question, write on footnote on mutta marriage. Mutta means enjoyment. It is a marriage for pleasure on payment of certain reward to the woman. Mutta marriage is void under Sunni law because the word used at the time of proposal and acceptance must denote an immediate and permanent union. Because under Sunni law, mutta marriage is not permitted once it is a permanent contract. Though it is a civil contract, it is permanent and immediate. The specified period may be a day. In a way, mutta marriage can be made for a day also, or a month or a year, that is a male Shia Muslim may contract mutta marriage with a Muslim, Christian, Jews, or fire worshipper one, but not the follower of any other religion. So mutta marriage with a Hindu woman is void. That is mutta marriage with a temporary marriage. So a female Shia not free to contract mutta, but a female Shia woman is not permitted to enter a mutta with a non-Muslim. It is essential to be valid of mutta marriage that the period of cohabitation should be fixed for a mutta marriage. The period of cohabitation must be fixed. There should be specified, some dower should be specified. If period is not specified, it should be considered as a permanent. If the period is not specified in the mutta marriage, that will be treated as permanent. Even in the partners called it a mutta marriage. The main incident of the mutta marriage, no mutual rights or inheritance is created. Once a mutta marriage, there is a mutta marriage under Shia law. Even after the death of the husband, wife doesn't get his property, or after the death of the wife, the husband doesn't inherit property. No mutual right of inheritance created between the spouse. But if there is an agreement to the contrary, such agreement will be enforced. If there is an agreement that during mutta marriage either spouse dies, then they will inherit the property, then that is all. And if the children considered legitimate, in case of mutta marriage, the children are considered legitimate and capable of inheriting from both parents. Wife is not entitled to maintenance, but she can claim maintenance under section 125 child. If the marriage is not consummated, the wife is entitled to only half of the dower. If consummated, then full dower. When marriage has been consummated, the wife is required to undergo iddat in case of death of her husband for a period of 4 months and 10 days. In case of pregnancy, this period is to be extended till delivery. The termination of mutta marriage authorized done by death of the husband is 2 course if she was menstruating and 40 days if she was not. Where there has been no cohabitation, iddat is not necessary. Husband has a right to refuse procreation. This is mutta marriage. You get a direct question, what is right short note on what is mutta marriage. So marriage comes to an end on the day of the term. When the day of the term, so 2 years, 3 years, 15 days, on the last day of the term, the marriage comes to an end unless extended. Husband does not have a right of divorce in case, because the marriage time period is fixed. So here the husband has, but the wife can terminate. But he can terminate that union earlier by making a gift of this term. You will gift of the term to the wife, then he can. Intersect and interschool marriages. Under Muslim law, there is no prohibition as to intersect and interschool marriages. Different school, as you know, Hanafi school, Maliki school, other schools. Thus, a Shia male, female may contract a valid marriage with a Sunni male and female. And so it does not imply change of sect or school. Thus, a Sunni woman contracting marriage with a Shia does not thereby become subject to Shia law. The parties to a suit are Muslim of different school, the law of defendant will apply. So you should understand, parties are Muslim, but the law of the defendant will apply. In nutshell, we discuss what is Muslim marriage. In the next class, we will discuss what is dowry.